What happens during the course of a personal injury trial in Idaho? Let me just try to break it down into what generally most people would consider as the various divisions of things that happen. When the trial starts, the very first thing is to pick the jury. And that is a very involved process. Because there'll be, if you have a one-party plaintiff against a one-party defendant, you'll probably have about 40 or 50 people in the courtroom, and from them, the 12 that will decide your case will be selected. That process is called a voir dire. It's kind of a weird, it's a Latin term that says to speak the truth, is where it's from. And the voir dire process is done strictly by lawyers, and it's controlled by the judge. And basically it's to answer questions with the prospective jurors and try to understand where they're coming from and whether or not they have propensities to that are favorable to you or unfavorable to you. Once the voir dire, and there's a process of actually striking juries. You have 4 automatic strikes of juries, and it ultimately whittles down to the 12 that are going to decide your case. Oftentimes these days juries, they add another jury or 2, 13 or 14, just in case somebody gets sick and has to leave or something. And at the end, when the case is done, the judge picks out the excess, and so that you're left with only 12 to make the decision. So that's the first step of the process. The second step of the process is what's called the opening statement. Each lawyer's opportunity to talk to the jury directly, not in a conversation way, but just to give them a statement as to what they anticipate in the way of evidence. And it's the opportunity to express what the theme of the case is to the jury. And opening statements usually last something like an hour or less, a half hour maybe. Judge also controls how much time for that. And the next is the actual trial process, and that is the calling of witnesses and presenting evidence. So the plaintiff, the one who was injured, who brought the suit in the first place, gets to go first. They call their witnesses and to talk to the jury about the case and what is presented as being at issue. That will often involve the plaintiff, him or herself, as well as the medical people who are treating them, as well as other people who know them and the like. So it's a matter of selecting all the witnesses favorable to the plaintiff and presenting them to the jury. Then the defense gets the right to cross-examine them, those same witnesses as well. Once the plaintiff is done presenting the witnesses and evidence on their behalf, then the defense has the right to go and do the same thing. They present their witnesses and their evidence or exhibits to the jury as well. Once all that's done, the plaintiff has one other opportunity for rebuttal. Anything that is newly brought up by the defense, the plaintiff gets an opportunity to rebut, which is usually quite a bit shorter than the original case. And judge, again, will be limiting how much rebuttal testimony will be allowed. So there's 3 levels, times at which people are calling witnesses and presenting evidence. Plaintiffs, the defendants, and then rebuttal. And once that's done, the case is considered submitted, and the judge has a jury instruction conference with the lawyers. That's a process that you would probably find excruciatingly boring, but it's a matter of what instructions the jury will be given on the law as to be applied against the facts and how they should make their decision, and the kind of ways they should go about making their decision fairly. And after the jury instruction conference, the next, and probably a lot of people consider the most important phase of the case, and that is the closing argument of the case. Each side opportunity to argue to the jury what the evidence actually presented to them what it should result in. What is a fair result of the case? But it's, kind of take the gloves off and make argument at that point. And once that's done, the case is literally submitted to the jury, and the jury goes back in the room and deliberates. And they identify a 4-person to kind of control how the process goes, and everybody waits until they return. And in Idaho, it's for civil cases, for tort cases or injury cases, it's required only that 9 of the 12 people agree. It's a 3/4 majority verdict in Idaho. So you don't have to have all 12 unanimously agreeing as you do in a criminal case. In a civil case, you only have to have 9. And then of course there's post-trial things that happened, but that takes some time, and otherwise it's possible to have an appeal. But for the most part, once the jury's in, that's the end of it, usually.